This is the podcast of the NOVA Center on Business, Human Rights and the Environment. Welcome.
Welcome to the NOVA Center on Business, Human Rights and the Environment. My name is Lise Smit and I'll be the Research Associate assisting on this episode. In this new episode, we will continue our series on perspectives on the Omnibus Package. And we welcome Professor Claire Bright, our founder and director.
Hello, everyone. It's a pleasure to be here, and I want to extend my thanks to Lise, but also to Lise Smit and Robert McCorquodale to be joining me on this conversation today. Lise Smit is a business and human rights advisor at Norton Rose Fulbright, and Robert McCorquodale is a member of the UN Working Group on Business and Human Rights, which is a 5 members independent expert groups engaging with the United Nations on issues of business and human rights. Lisa, Robert, welcome, and thank you for being here. So I would like to start this conversation by asking you, Lisa, perhaps if you could summarize the main changes that the Omnibus Package seeks to bring to the Corporate Sustainability Reporting Directive and the Corporate Sustainability Due Diligence Directive in particular for our audience.
Thank you, Claire, and thank you for this invitation. So yes, CSRD and CS3D are both in effect already, with the first wave of companies that are required to report under CSRD this year on the 2024 financial year. And then on 26 February, as you mentioned, the European Commission published the Omnibus proposal, which consists of 2 draft directives. Firstly, there's a dates proposal, which proposes to postpone the deadlines applicable to CSRD and CS3D and the second and third wave of companies required to report under CSRD. And then secondly, there's a substantive proposal which seeks to make more substantive changes specifically to the threshold of CSRD, which is estimated to bring down about 80% of companies that are currently caught would then be out of scope, and also to some of the substantive requirements of CS3D. Of course, in the meanwhile, while the Omnibus is not law yet, so both draft directives are currently in force, and the Omnibus proposals will have to progress through the EU's legislative process to be passed. In the meanwhile, the current CSRD and CSDDD remain law at EU level, and most member states have already transposed CSRD into national law. The European Commission has asked for the dates proposal to be fast-tracked to allow member states to already transpose it by 31 December of this year, 2025. That would be just in time to postpone the second wave of CSRD reporting. And so arguably the most immediate effect of the Omnibus proposal is currently felt by companies that fall within the first wave of CSRD and already required to report this year, and specifically actually in member states which have not transposed CSRD. Last year, the European Commission commenced infringement proceedings against 70 member states which had missed the July 2024 transposition deadline. And there are still a few member states which have not yet adopted CSRD transposition legislation. So companies that are now required to report under CSRD this year in those jurisdictions are currently wondering what the position is and what will happen. Obviously, so the dates proposal itself, the Omnibus dates proposal, does not affect first wave companies, but if it is indeed fast-tracked and member states are required to transpose it by December, non-compliant member states would in any event have to transpose CSRD by then, because otherwise there would be nothing to postpone, if you will. And so to add to the confusion, the Omnibus substantive proposal proposes to remove first wave companies from the scope of CSRD altogether. And obviously we don't know whether that will be adopted in this current form, and if so, when. So it might be that first wave companies are and would be legally required to report now and for a few years, and after that become entirely out of scope. And that is at least what is proposed by the Omnibus. So we'll have to see what happens in that respect. With respect to CS3D, just in terms of some of the main changes that are proposed there, obviously, so in terms of CSRD, the thresholds in the substantive proposal will be sort of reduced. So listed SMEs would be out of scope if it goes through in its current format. It will be, the cutoff point will be raised to 1,000 employees for EU companies and 450 million euros turnover in the EU for non-EU companies. But that, like I said, in the substantive proposal only, rather than the dates proposal, which is being fast-tracked. Then in terms of CS3D, the substantive changes that are being proposed, just very briefly, there are a few there, in addition to the dates, the postponement of the dates. The Omnibus proposes that the second phase of, if you will, of supply chain risk assessment will be sort of not limited, but you would only have to do in-depth risk assessment following risk mapping for indirect suppliers where there's plausible information of risks. I think we'll get to this point a little bit in a bit. And then a few other amendments proposed. No longer will the civil liability take place at EU level. It will take place at member state level. So claimants would have to bring claims in terms of the domestic system. The other parts of the civil liability is still in, so full compensation, injunctive relief, etc. The one key other part that's being proposed to remove is the mandatory override provision, which is the the provision that allows for the EU member states law to be the applicable law if the harm has taken place in a different jurisdiction. The regularity with which one would be required to undertake due diligence has been changed from 1 year to every 5 years. And then lastly, the CS3D would no longer require termination of business relationships under circumstances, although it would still require suspension. So I'll stop there as a brief overview, although I'm hoping we can dive into some of these aspects.
Thank you so much, Lisa, for that very helpful overview. One of the things that, one of the main criticisms that has been addressed to the Omnibus package, and we were actually discussing that in our first episode with Heidi Hartela and Richard Gardiner last time, was the fact that the Omnibus proposal is seen as being largely disaligned with international global norms like the UN Guiding Principles on Business and Human Rights and the OECD guidelines for multinational enterprises on responsible business conduct. So my next question would go to you, Robert, and I would like to ask you, what do you see as the main areas of disalignment of the Omnibus proposal with the UN Guiding Principles on Business and Human Rights in particular?
Thank you, Claire, and thank you particularly all the important work that you do through the NOVA Knowledge Centre for Business, Human Rights and Environment. It's very important to have that engagement across business, states, and particularly in your case, academic, but also other CSOs. That engagement is important and obviously part of this podcast. To answer your question in relation to the UN Guiding Principles, as you say, it's clearly one of the kind of authoritative norms in this area, and it's also, of course, part of the mandate of the working group for the promotion, dissemination, interpretation of the UN Guiding Principles. Now, why that's particularly relevant to the CSDDD, CS3D in the Omnibus is that specifically stated a number of times in the CS3D is, of course, that the directive is meant to be consistent and as a means to their terminology to actively promote the global implementation of the UN Guiding Principles. So right at the heart of it is this sense of it being part of the smart mix of measures, national and international, mandatory and voluntary, of regulation to implement the UN Guiding Principles. So it is disappointing when the UN context has been of attempt to implement the guiding principles when we see the Omnibus taking a step back from that. Now, what are our key concerns? Well, a number of the concerns are, for example, that one of the core elements of the UN Guiding Principles, which is human rights due diligence, should be conducted, if it's in accordance with the UN Guiding Principles, on a proportionate and risk-based approach. It is a process that needs to be ongoing, not a one-off process, and it needs to be the central element in the implementation by business of the UN Guiding Principles, because this kind of risk-based approach to human rights due diligence means that businesses should focus on areas which suffer from the most severe impacts, rather than focusing on items that may be most readily visible, but actually may not be the most severe. And that thorough and wide-ranging human rights due diligence helps businesses to understand better their risks, their impacts, and that this shouldn't be artificially limited or restricted. But what the Omnibus does, by restricting this scope of human rights due diligence only to direct partners, as Lisa mentioned, limits it to direct suppliers and tier one. And that's a significant move away from the UN Guiding Principles, because it's really important for businesses to examine the whole of their value chain, including that's the supply chain and the production chain, not just part of one part of that value chain. And therefore, there's concern by the working group of this being diminished in the Omnibus so-called simplification practice. I would also add, and picking up one of the points that Lisa made, is that only assessing these efforts once every 5 years is contrary completely to the UN Guiding Principle provisions, which says there should be ongoing human rights due diligence efforts. Reduction in review just once every 5 years can mean the substantial adverse human rights impacts, which will occur over those many years in between, could well be completely ignored with consequent harms to rights holders. And linked with that, as Lisa was talking about, is this concern about the throwing away of any generalized access to remedies, because a civil liability regime focuses the decision-making of a business on the severity of risks and on actions to prevent and mitigate those risks. And there's a lot of evidence to that. The evidence from the UK Modern Slavery Act, for example, which has no civil liability regime, shows time and time again that without having any kind of effective enforcement regime, it ends up not being undertaken by business, or undertaken in a way which is very far from the substantive action we would like. And also this consequence of that means accountability is left to EU member states' discretion without a harmonized approach. And a lack of harmonized approach, as the three of us know from our work together on these matters, is deeply problematic for business. Business wants a harmonized approach. So to throw that away for this supposed simplification package is not a good idea. And as well as, of course, hampering access to justice for victims. And the final point I just want to make in terms of coherence with the UN Guiding Principles is that impact assessments, human rights impact assessments, which of course include environmental impact assessments and climate change impacts, also must include meaningful stakeholder engagement and all the aspects of the UN Guiding Principles. And that's part of ensuring transparency and should be in this regulation. And what we've seen here is certainly not that. And certainly the consequence that reducing the requirement of meaningful engagement with stakeholders to just what's considered relevant stakeholders creates a real risk that certain important voices, particularly those beyond tier one, will not be heard. And I have examples from my previous work where what happens is companies will just pick and choose some of the voices they want to hear, and key and important voices, such as, let's say, Indigenous people, may not be heard. And I think that's a real concern if you want to take the overall approach and the important elements of the UN Guiding Principles. Thanks, Claire.
Thank you so much, Robert. That's very helpful. And sort of continuing on that, I was wondering, Lisa, if you could tell us a bit, what do you see as the most problematic proposals in the Omnibus proposal?
Thanks, Claire. I think just picking up also on what I was saying, I think I'll focus on sort of 3 points under this heading. Firstly, when it comes to the risk assessment aspect and the direct and indirect partners, the CSRD, as it currently is enacted, requires a two-phase approach to risk assessment. First, you must undertake a risk mapping of the company's own operations, subsidiaries, and the entire supply chain, direct and indirect suppliers, to identify where the risks are most severe and likely. And then based as the second phase on this risk mapping, the company needs to undertake in-depth assessment of those areas where the risks are most severe and likely. And this is literally in, provision A and provision B, as a two-step approach. The Omnibus proposes to amend this second phase only, so B, namely the in-depth risk assessment phase, by requiring companies to undertake in-depth risk assessments of their own operations, subsidiaries, and direct suppliers where the risks are most severe and likely, and of indirect suppliers where plausible information suggests that there may be risks there. So the first step, A, risk mapping, still applies to the entire supply chain, direct and indirect partners, based on severity and likelihood in alignment with the UNGPs. But the second one would be there would be a distinction between direct and indirect suppliers, and the focus would be on focusing on indirect suppliers where there's plausible information. Now, obviously, this draws a superficial line between direct and indirect suppliers, which, as Robert mentioned, is not drawn in the UNGPs. But in our view, this the way it's currently phrased in the Omnibus is not practically that different from the current requirement for two reasons. Firstly, you will always decide where to take in-depth assessments based on plausible information anyway, even in your own operations and your direct suppliers. That's what the initial risk mapping is all about, is to try and find where those risks are most severe and likely. And in that way, it also, it still would be UNGPs consistent if that is the way that it is applied, because you need to focus on those areas which you have reason to believe that there may be risks that are severe and or likely. The flip side of this coin, if to defeat the purpose of risk-based due diligence, if you're expected to undertake the same level of in-depth assessment of every single actor in the value chain, regardless of whether they're an indirect or direct supplier. And this is also that kind of blanket approach is not what's currently required by the existing CS3D or indeed the UNGPs. And just to flag there that the wording in Omnibus, it says that this is influenced by the German Supply Chain Due Diligence Act, which refers to substantiated information, which one could argue is even a higher level than plausible information. Plausible is a little bit lower than substantiated, I would say. And in that context, it was expressly indicated that, as it is in the explanatory notes of Omnibus, that this refers to information that is in the public domain, and it's therefore not possible to circumvent this by turning a blind eye. And the explanatory notes, if you read that in the Omnibus, it's very clear that this approach aligns it with CSRD, etc., which also applies to the entire value chain. So this currently, the way our approach is that this is not currently as problematic and limiting as it would be if it is all even more limited, and this line was even further delineated during the forthcoming negotiations, which could, for example, if you remove the plausible information lens and just write indirect suppliers out entirely. I mean, that would be problematic, I think, from a practical perspective, from UNGP's alignment perspective, and just from a coherence perspective, really, because, I mean, as I'll get to shortly, I think the main thing that we will also talk about later is that there is currently a lot of other EU laws that do require full value chain due diligence. So in that sense, the EU's own laws wouldn't be aligned with themselves. I suppose my second observation is that this is what I think is currently the most problematic new introduction post-Omnibus, is it proposes to introduce a very strange new provision that effectively prohibits companies from asking suppliers with less than 500 employees questions that are not aligned with the also to be introduced voluntary reporting standards for SMEs, unless the company requires this for information for undertaking due diligence, and B, cannot obtain this information by other means. And the Omnibus actually proposes to introduce a similar provision in CSRD as well, this time in relation to companies with less than 1,000 employees, although there it notes that the CSRD due diligence provisions would take precedence. Now, it is said that this provision was added in order to reduce the reporting burden on SMEs. But this is bizarre because a company with 500 employees is not an SME or even a medium company by the EU's own definition. And so this provision is aimed at sparing companies that are significantly larger than the vast amount of EU businesses from answering questions, while at the same time increasing the burden then on in-scope companies who will now need to ensure that the questions are, on the one hand, comprehensive enough to identify the issues and address the issues that they need in terms of the law, but at the same time not exceeding the limits of the VSME standards. And they will still have to ask these questions, given that, as we know, due diligence at its essence is about engaging more deeply, and asking questions is the starting point for risk mapping and for identifying risk, and it is how you exercise leverage, it's how you monitor progress, it's how you check whether their contractual assurances are passed forward, it's how you take forward your preventative and your correction action plans. And all of these are required by CSRD itself, and you cannot implement them if your ability to ask suppliers questions is restrained. And it's not just in terms of asking the questions in a questionnaire, but it's actually, as Robert was saying, it's an ongoing deep engagement. It's following up, it's deep diving, it's figuring it out together. It's a dynamic process on how to solve and how things can be improved and how everyone can take about accountability and identify issues when they arise. So it seems that this provision, this new provision, is based on an understanding of due diligence as a questionnaire rather than an ongoing dynamic engagement as per the UNGPs. And what we will inevitably end up seeing is that companies will be unilaterally share standard checklists without any bilateral engagement about what's actually happening in the local context. And we've seen a little bit of that happening at the beginning with the German supply chain due diligence law. So that is I think, the most very novel and bizarre introduction. And what's even stranger about it is that it is, as I said, it contradicts directly the EU's other supply chain laws. For example, the EU deforestation regulation, which will start to apply in December of this year, 2025, on products that are already being made today. And that requires information on due diligence all the way to plot level. So bypassing every single indirect supplier all the way to where the plot. And then the EU forced labor regulation, which will ban products made with forced labor from 14 December 2027, again, applies to the entire value chain, direct and indirect suppliers, including SMEs. That's already law as well. So it's not really clear how companies will be able to practically comply with these laws if they're not allowed to ask questions of suppliers with less than 500 employees. And then lastly, the third point here, just on the problematic question, the civil liability, obviously this is something discussed at length in the past. The removal of the EU level civil liability in itself is not necessarily the biggest issue, provided that CSRD would be transcribed in national law. What seems to be the biggest issue is the removal of the mandatory override provision, because that would mean that in a lot of cases where the harm happens elsewhere, and we know this is often the case with transnational business, the claimants would not be able to actually bring these claims in the domestic system, even though there is a national transposition law which makes this conduct a legal requirement. The due diligence is legally required. A breach of the due diligence would cause them harm, but because of the way it's applied, the applicable law would be the law in that jurisdiction, not the jurisdiction where the company is subject to its own national law. And so we've seen this happen in other contexts, and it seems that removal would be probably the most problematic part of the civil liability removal. Just to note there that it's interesting that in the current CS3D, civil liability is limited to harms caused by a failure to prevent and mitigate harms under Article 10 and 11. But this limitation is also proposed to be removed by the Omnibus. So if it goes ahead and in its current form, and let's say the monetary override provision is put back in, claimants should be able to bring claims then for harms that are caused by any part of non-compliance to CS3D, not just the prevent and not just Article 10 and 11, prevent and addressing actual potential and actual impact. So that's actually a little bit of a widening in a way, because there could potentially be other parts of the directive that could lead, let's say, to indirectly to harm, and then they could potentially try and frame a claim around those.
Thank you so much, Lisa. And in your intervention, you spoke a few times about the German supply chain due diligence law. And it is interesting indeed to note that the Omnibus proposal follows a sort of closer alignment with the German law, but without really taking stock of the lessons learned from the German law. And that came very clearly from your intervention. We have seen in practice now that the German law has been helpful in driving in-scope companies to start carrying out or to improve existing processes on human rights and environmental due diligence. However, the experience of the German law also shows that a number of companies, and especially the ones that started to carry out human rights and environmental due diligence after the law was adopted, so not the ones that had already started on that journey on a voluntary basis, sort of based on the international standards that already existed. Well, so those companies, they have tended to take a very compliance-orientated approach rather than a risk-based approach, which is what also Robert was mentioning, is what international standards expect companies to do. And that is also what the CSDDD in its version as adopted in June last year attempted to tackle, so taking stock of the lessons learned from the German experience and insisting on the importance to carry out risk-based due diligence rather than adopt that compliance-orientated approach, which is the one that is actually burdensome and is not actually necessarily helpful to get better outcome for the people on the planet. Lisa, you also mentioned SMEs, and that brings me to my next question to Robert. There has been pressure from some SMEs for the changes brought about or suggested by the Omnibus package. Robert, do you think that it's likely that all SMEs will be better off with the simplification package?
That's a great question, and I think your comment about having the sense to which SMEs were already involved in the earlier forms of the CS3D and, of course, other discussions makes it even more puzzling in a way that some of them have pushed hard back against it. And in particular, one of the key elements of the CS3D was to provide assistance to SMEs, capacity building, training, where there's an obligation on the larger business. And it seems that has been disregarded in the sense of this push to say SMEs shouldn't be considered, it should move just to tier one. And I'm not convinced that by restricting this to only tier one is a protection of small and medium-sized enterprises or micro enterprises, because there are significant benefits for SMEs of being included in a human rights due diligence process, not only because, as Lisa points out, there's already existing EU law which will include them, such as the forced labour law, but also because a human rights due diligence process, which includes an SME, can help that SME to identify potential risks in their own operations or as part of a larger supply chain. And I like the terminology Lisa used, as part of this dynamic process, so that it can have benefits. For example, if a SME is currently on a short-term agreement with its company to which it's supplying, and it shows that it is undertaking human rights due diligence, it can argue for a longer-term, more stable, more sustainable contractual relationship with that, let's say, retailer, because that way it is part of that process and can ensure its own economic stability. and also taking listed SMEs out of the scope now will cause quite some difficulties when there are a range of different stock exchanges which are requiring some of these particular elements. So that I think it's a misunderstanding by those SMEs who are pushing for this change towards the omnibus of the sense to which they should be taken out of this process. And I'd add just one more thing, which links with an earlier comment Lisa made. We often forget that one of the innovative elements of the CSDDD is in relation to these supervisory mechanisms. I think there's a real possibility of potential of these supervisory mechanisms being quite effective as a means of clarifying, setting out guidance for all businesses, including SMEs, and yet it's not clear what is wanted of them now. Because if it's meant to be truly a simplification process, that simplification can come through guidance, and that can include supervisory mechanisms providing that guidance. So I'm concerned that the press coverage of this, which includes the element that it's a pressure from SMEs, may misunderstand that actually there's a huge potential benefit by including all businesses. And I would just add one other point, which is that the UN Guiding Principles, of course, says all businesses can have adverse impacts on all human rights. It can be a small micro company which is using child labour. It's not like it is only going to be in the large businesses where this is going to occur. So I think there needs to be a rethinking about the inclusion and in this instance the exclusion of SMEs in this process. Thank you.
Thank you very much, Robert. And to add to that, again, if we look at the experience of existing laws, we know from France, for example, there have been studies that show that SMEs have been asked by larger companies in scope to do to take certain measures as part of the due diligence process, but that they have not been accompanied by these larger companies in scope in doing so, either financially or otherwise. And so it is actually helpful to include some protection mechanism within the law, which CSDDD is doing through various provisions to make sure that they are being actually accompanied rather than simply trying to ignore the fact that they will be impacted by the law, but in a way that can also be positive by helping them and providing them with the support that they need. Lisa, did you want to add something on that too?
Yes, thank you, Claire. Just tying in with the this interesting discussion, absolutely agree on this, and then linking in with what you were saying about the risk-based versus the compliance approach in this context as well. That if you want to sort of post those ones against those two approaches against one another, that is the way that it is applied is relates to how the law is framed and how it is applied by regulators and the judiciary ultimately. Because if it is seen as a procedural law, it's framed as a procedural law, it's got a lot of checklists in there, it tells you what to do, when to do it, who to do it with, absolutely every single thing is spelled out for you. It does further and further and further remove the discretion that companies have under the UNGPs to identify these risks for themselves and literally address them. And you can also look at other laws that are more, address. You said they try to cure the ill, that they seek to cure more directly. In a ironic way, the EU's other laws, forced labor and deforestation even, would be more risk-based at the end of the day, because at the end of the day, they don't necessarily ask what you do or how you go about doing it, but the question is there forced labor in this supply chain of this product? And that's sort of ultimately what's going to determine whether it's, gets into the EU or not. And so in that way, it really drives the mind. So sort of what is the risk? The risk is the risk of forced labor. We need to alleviate that. We need to prevent that. We need to address that and remediate that where it does happen, and then we will be able to get the product in. So that is a risk-based model. Ironically, even though the legislation itself doesn't necessarily, frame it in that way, and then that for the same reason you have the UK Parliamentary Committee already in 2017 proposed that the UK uses its by now sort of homegrown traditional model of the failure to prevent mechanism, which is a failure to prevent X. We have that in failure to prevent failure to prevent bribery, tax evasion, fraud already in the UK. What that does is it's really kind of places the responsibility on the company. You have as a defense the availability of saying you've got adequate measures / due diligence processes in place that are adequate or reasonable, or whatever the legislative language is. But the fact is that drives the mind to the ill that you wish to cure. So what is it that we wish to cure? We want to prevent, in that case, bribery, but in this case, human rights and environmental issues in the supply chain. We're going to focus on where it's actually happening, whether it's happening in an SME or if it's happening in a different country. That's not the issue. The issue is we need to prevent, address, and remediate. Otherwise, the consequences are going to be X. So I think that just to tie in with that, I think this is a constant discussion taking place around the world.
Thank you very much, Lisa. And that brings us to the end of our episode. I wanted to thank you very much for both you and Robert for taking the time to be here with us and sharing your extremely valuable insights. And invite our audience to stay tuned for our next episode on the perspectives on the Omnibus Package, which will focus on the issue of access to remedy in civil liability with a scholar, Nicola Bueno, and the co-director of ECCHR, Kanel Levitt. Many thanks to you both again, and bye-bye. See you next time.
Thank you. Bye-bye.
Bye.